Hi, this is Kaushik Ranchod here from the Ranchod Law Group, and welcome to our immigration show with another update. What we're talking about today is the marriage-based green card. This is one of the most frequently filed cases here at our office, and we're going to break down the marriage-based green card process, talk about the procedure, who can file, what's the best process, the interview. So we're going to break it all down, so you'll want to watch this video till the end. All right, let's start off with the who can file with the marriage-based green card process. So with the marriage-based green card process, of course you have to be married. That's an important distinction though, because you can't be engaged. Second, a lawful permanent resident as well as a U.S. citizen spouse can file for their loved one who's either abroad or in the United States. If you are a lawful permanent resident, the distinction here, the difference here is that you can file, but you have to make sure to get to the green card, the 485 process, or if you're doing a spousal abroad immigrant visa, you have to make sure that the priority date's current to get to the final step of the process. And the way that you determine that is with the visa bulletin. With the marriage-based green card, if you're adjusting status in the United States where your spouse is in the United States and you're a lawful permanent resident, you need to look at that visa bulletin if you want to file the 485. If your spouse is a U.S. citizen, if you're a U.S. citizen filing for your loved one from abroad who's in the United States, you can do what's called a one-step, the I-130 and the 485 at the same time, and because you're an immediate relative. Now, if you're a lawful permanent resident, you have to make sure that the priority date's current. So if the priority date's not current, you have to wait for it to be current in order to file for that 485. If it is current, you can file both of those simultaneously. Now, if you're married and you're a U.S. citizen or lawful permanent resident and you're filing, the most common process here is filing for the adjustment of status. That's filing for their green card application with your spouse in the United States. In this contrast, filing an immigrant visa where your spouse is outside of the United States, waiting outside the United States to come into the United States. So I'm going to talk about the adjustment of status process first. Some of the forms that are filed with the adjustment of status process are 485, the I-765 for work authorization, the travel document form I-131, the affidavit of support form demonstrating that your spouse is above if you're a U.S. citizen, you're 125% above the poverty guidelines, or you have a joint sponsor demonstrating that, the form I-944, self-sufficiency. Now, this could be changing. Immigration laws are always changing. With the Biden administration, this form I-944 may no longer be in effect, so you always want to check the USCIS.gov website to determine whether or not you'll need that form. As of today, you do need that form, but immigration law frequently changes, so you'll want to make sure you watch our channel and check the website. Some important things to note is that there used to be a Form G-325. There's no longer a Form G-325 that's required. There is the Form I-130A that goes along with the Form I-130. When you're filing in the United States, filing for work authorization is one of the benefits of applying for the marriage-based green card, because you can get work authorization while your application is pending. And that's used to take only about 90 days, up to 90 days, but now we're seeing it anywhere from around 5 to 6 months, and this can change because these are government processing times and it's dependent upon the government. Now, an important concept to be aware of with the adjustment of status process is a concept called non-immigrant intent. It's really important to be aware of this concept because the USCIS could find that you could be found of having visa fraud if you came in on a visitor's visa, because they may find that you misrepresented your intent when you came into the United States, depending upon when you got married and other actions. So there used to be something called a 30, 60, 90-day rule, basically evaluating what your non-immigrant intent was depending upon when you got married within 30, 60, or 90 days. That's been replaced with the 90-day rule now. That's just something that you'll want to be aware of, because you shouldn't be coming into the United States with the intent to get married to your U.S. citizen spouse. If that's the case, then the most appropriate procedure is the immigrant visa. That's where you'd be applying for the I-130 in the United States and then having the interview at the U.S. Embassy abroad. In both the immigrant visa and the marriage-based green card, when the I-130 is filed, what the USCIS is evaluating is whether or not you actually have a real relationship. So that they're determining that primarily based on the documents that you provide with the I-130 petition. And of course, you have to have a certified copy of your marriage certificate. You need to demonstrate that you were previously divorced, that you've actually had a prior divorce that is been finalized. So you'll have to show evidence of that. So these documents are extremely important, because they're not going to just take your word for it and assume that you have a real relationship. You have the burden of proof to demonstrate that you have a real relationship. And that's why joint documents, evidence of your real marriage, are extremely important. And we're going to talk about this more towards the end of the video, where I talk about the interview, because I want to make sure that you're getting as much information as possible for this interview as well, that I can talk about in this video in the time that we have. All right, so now I'm going to move on to the application procedure. With the marriage-based green card process, you get to file with the local service center, and you file all the forms that I mentioned before. Those are some of the forms. Check the USCIS website, because it's always changing, but you'll be submitting your I-130 petition, 485, work authorization, travel document, affidavit of support, income of self-sufficiency, I-130A, and any other documents that may be listed on the USCIS website. When you submit those forms, you'll get usually a receipt notice within about a month that confirms that your application has been filed. Then you'll be scheduled for biometrics. That's where they're going to make sure that you are not inadmissible because you have a criminal issue that would make you inadmissible. And now, if you do have a criminal issue, you'll want to consult with an immigration lawyer to make sure that, first of all, whether or not you should even be applying for a marriage-based green card. And then second of all, if you're applying, if you may need a waiver. And third of all, how to address that criminal issue on your application. So the biometrics, they're basically doing an FBI background check on you to see what kind of record you have. Interviews are typically, currently right now, being scheduled within a year from the time of filing. This could change. This is subject to government processing times. We've noticed a slowdown with COVID. One point, applications were taking around 4 months, and now it's slowed down significantly. So these times are always changing, and the way that you can look that up is based off of the processing times posted at the USCIS.gov website. What I'm telling you right now are the times that it's taking right now. During the time that your application is pending, then you'll get the work authorization and the travel document. The three common mistakes that I see in a filing is, one now is not answering the questions correctly or not answering the questions at all. And this is the USCIS is getting very, very picky on this. So for instance, if you don't put NA on any box, empty box that you wouldn't fill out, then they could reject the application. And this is just, in my opinion, another way for them to make it more difficult for you to have a successful filing. But there are even absurd questions that you wouldn't normally answer where they're rejecting the application because their NA is not submitted in that box. The second mistake that I see is that not providing enough joint documents with the application. So you want to make sure that you provide as many joint documents with your application as possible, and also bring those joint documents to the interview as well. And then the third is the affidavit of support. That's a very tricky form, especially if you're on the borderline or you need a joint sponsor. If you need a joint sponsor, they also need to be making above 125% of the poverty guideline, or as a U.S. citizen spouse, you need to be making 125% above the poverty guideline. And now with the I-944, the self-sufficiency, it even needs to be more than that in certain situations. The affidavit of support form, typically if you previously were making 125% above the poverty guidelines, that would have been enough in and of itself, as long as you take public benefits as the beneficiary. Now, with the 944 income of self-sufficiency, they're also looking at other factors. One, do you have a credit report? Are you going to be taking health insurance, or do you have health insurance? Have you taken public benefits within the last 3 years? So this is another common pitfall that I see people make, is with this form I-944 and the affidavit of support. We will continue to see if the I-944 is going to be valid in the Biden administration. Biden has said that he's going to be reversing a lot of Trump's policies. One of those is that form I-944, income of self-sufficiency. Okay, so a year has passed. So now let's talk about the interview process. So then you're going to go to the interview. Both of you should show up to the interview. It's really important that both of you show up to the interview, or otherwise they could deny your application, because they want to interview both of you to determine that you have a real relationship. So at the time of the interview, they're going to ask you questions about your relationship. Questions like, where did you get married? When did you get married? Where did you, well, pre-COVID it might be, where did you last go out to dinner? These types of questions to evaluate the validity of your marriage. And if the interview doesn't go well, you could be scheduled to come back for a second interview known as a fraud interview. The fraud interview is where they separate you and they ask very detailed questions to determine whether or not your answers match up. And some of the questions might be like, what kind of toothpaste do you use? What kind of soap does your spouse use? Who does the laundry? And these questions are more specific. Then they'll make sure by interviewing both of you that you're answering them both the same way. And if you're not answering them both the same way, then they are going to ask why there are discrepancies. So you want to get it right the first time so you don't have to go to an interview the second time. That's where also at the interview, they're going to review your joint documents. So you want to have your joint documents at the interview, as well as I would recommend you bring a copy of your application, even though it was submitted, because sometimes they misplace things. So that way you're prepared in the event that they don't have a document. You want to make sure you also bring everything that's on the interview notice as well, so you're fully prepared. As the Boy Scouts say, as I was a former Boy Scout too, be prepared. And that applies into all aspects of life, especially your interview. That's where they're gonna look at your joint documents, for instance, joint bank accounts, joint lease. They wanna see that you actually have a real marriage as demonstrated through your documents. That's where they're also gonna look at your financial documents and updated financial documents as well. Updated tax returns if the tax returns are old from the time of filing. And then you'll get a determination. Not typically at the interview, what I've seen is that they say they're going to put it under further review, and then they'll notify you by mail. If there's something that's missing in your application or they want more information, they could also issue a request for evidence. And then you'll get your green card in the mail. Now, if you've been a green card if you've been married less than 2 years, then you'll want to watch my video about the I-751, because you're going to need to file for a conditional, removing the conditions on the green card through the I-751. All right, I hope this video serves you. Thank you for tuning in. And I will see you next week. You're amazing for taking the time to better yourself by watching this video, and hit the like button and subscribe so you can continue to get updates. Thank you. Bye for now.